Good morning, everyone. It's an honor for me to address this distinguished audience on the topic of religious freedom in Turkey. And the questions we'll be discussing over the next 2 days relate to the protection of religious freedom for all in Turkish constitution. What is the most successful arrangements to ensure that both the rights of the members of the minorities and the rights of the members of the majorities are protected? First, a very brief overview of my presentation. I will focus first on why the principle of neutrality and the obligation to ensure pluralism are important in this time in the context of Turkey. Then I will briefly go over some key normative demands of human rights law on state-religion relations to remind us all of the international norms that are applicable to Turkey. And lastly, the main part of my presentation will focus on Turkey and some of the freedom of religion or belief issues where the principle of neutrality and obligation to ensure pluralism are relevant and should be applied. So why focus on the principle of neutrality and the obligation to ensure pluralism today? Because in the context of the new constitution for Turkey, these are very relevant principles and hold fresh opportunities to advance protection of religious freedom for all. Turkey has been going through a process of change, including state-religion relationship, and the principles of neutrality and pluralism are two of the key norms that need to inform the decisions that are made in this process of change. Some indicators of this change are a new interpretation of secularism by the Turkish Constitutional Court, which it called liberal secularism, but then went on to justify state monopoly over religious education. A new way of relating to non-Muslim communities under the AK Party, the removal of the ban on the headscarf for public servants, change of the mission of the Presidency of Religious Affairs, increased state interest in the involvement in the moral development of individuals, which always includes a religious dimension, including children, youth, and prisoners, and selective inclusion of religious practice and discourse in public events by senior public officials, including prayers in opening ceremonies. What I want to stress is that the more the decisions that lead to these changes take into account Turkey's human rights obligations in the sphere of religious freedom, the more Turkey will advance the protection of religious freedom for all. In Turkey, there is a unique state-religion relationship which has evolved over time with numerous factors affecting the process. It's a secular state protecting religious freedom in its constitution, yet this formula has not resulted in an effective protection of religious freedom for the majority and for the minorities. There are many paradoxes. There's the Presidency of Religious Affairs, the compulsory religious culture and morals lessons. The state continues to determine what is a worship place and what is an acceptable manifestation of religion or belief, and what is an acceptable title for a religious leader. Indeed, Turkey has a unique state-religion relationship that affects the protection of religious freedom. Yet Turkey is not alone. As we have heard previously about the different examples in the world, there are very variety of relationships between state and religion, some strictly religious, some strictly secular, and many other varieties in between. However, normative demands derived from human rights obligations often challenge these historically evolved state-religion relations for all states, not only Turkey. Human rights law does not explicitly prescribe a certain state-religion relationship, but it also doesn't give states a blank check to do whatever they want to do. These obligations inevitably have implications on the manner in which state-religion relations are formulated. The principle of neutrality or obligation to ensure pluralism are important normative demands. However, let me point out in the beginning that these would not on their own ensure that religious freedom is protected effectively. it is important to remember that human rights are interrelated, interdependent, and indivisible, and together establish a meaningful framework for the protection of human rights, including religious freedom. Let me briefly go over some of the normative demands that human rights law creates for states. And here I specifically focus on the International Covenant on Civil and Political Rights and the European Convention on Human Rights, which are both applicable to Turkey. According to the Human Rights Committee, the fact that a religion is recognized as a state religion, or that it is established as official or traditional, or that its followers comprise the majority of the population, shall not result in any impairment of the enjoyment of any rights under the covenant, including religious freedom and protection of minorities. Non-discrimination is an important norm with far-reaching effects on the protection of freedom of religion or belief. An education system that would make religious instruction compulsory would be impermissible, because states have to respect the rights of parents to ensure that such education is in conformity with the philosophical or religious beliefs of parents. A theocratic state would be incompatible with the Article 9 protecting religious freedom under the ECHR. In San Marino, for example, where parliamentarians were required to take an oath on the Gospels in order to be able to take up their seats, this requirement was found to be a violation of Article 9. Where non-believers are required to pay for the taxes to support a state church, the European Commission found that this obligatory tax was incompatible with Article 9, and it would force someone who was not a member of the church to support the religious elements of that church. Pluralism goes hand in hand with democracy. The European Court of Human Rights held that pluralism is indissociable from a democratic society, and freedom of religion goes with it and depends on it. Therefore, the autonomous existence of belief communities must be ensured. The autonomous existence of belief communities is indispensable for pluralism in a democratic society, and is thus an issue at the very heart of the protection of human rights schemes. About neutrality, in exercising their regulatory powers in the religious spheres, and in their relations with various religions or beliefs, states have a duty to remain neutral and impartial. And this duty of neutrality and impartiality, as defined by the European Court of Human Rights, is incompatible with any power on the state's part to assess the legitimacy of religious beliefs and their manifestations. Although there is not an explicit reference to neutrality in human rights conventions, ultimately, this principle can be derived from these norms. We also don't find a definition of neutrality in the jurisprudence of human rights courts. The UN Special Rapporteur on Freedom of Religion or Belief, Heiner Bielefeld, says that neutrality is about fairness. State which is in charge of guaranteeing human rights should not favor any religion or belief, or one set of religions at the expense of another. And neutrality doesn't mean that the public space should be purged of religion or religious symbols. For some, state neutrality may be a myth. You may think it's very difficult to achieve. Nevertheless, we have to strive for it and aspire for these principles and acknowledge them as the norm that we use to assess state behavior by. And courts need to be able to hold states accountable for their commitment to neutrality. The Turkish constitution does not enshrine the principle of neutrality, or does not recognize equal distance to all religions, and does not include a provision respecting pluralism. The constitution drafting process was an opportunity to move forward in relation to the principle of neutrality and pluralism. In the constitution-making process, religious communities have participated eagerly. Interestingly, when belief communities made their submissions to the Constitutional Reconciliation Commission, most of them refrained from making a reference to a secular state, and instead emphasized real equality, protection of the right to freedom of religion belief in line with European Convention on Human Rights, equal distance to all religions, pluralism, as well as neutrality. In my view, these legal terms present fresh opportunities to advance the protection of religious freedom in Turkey, because they are more specific and arguably they are more free from the sensitivities around the principle of secularism in the Turkish context. Unfortunately, the political parties were not able to reach a consensus on these principles. The Republican People's Party and the Peace and Democracy Party made a joint proposal on neutrality and pluralism in the context of freedom of religion or belief. It said, "The state is neutral toward all religions and beliefs in its transactions and acts. State respects social pluralism based on the diversity of religions, beliefs, and convictions." This proposal was, however, rejected by the AK Party and the Nationalist Movement Party. These responses, however, seem inconsistent with the views of the society. A TESEF study found on the expectations on the Constitution found that about 70% of those interviewed said that they agree that the state should be neutral on the face of all freedoms, including the headscarf, sexual orientation, and other preferences. Now let us consider some cases where the principle of neutrality and respect for pluralism are applicable. And these cases are based on the findings of our monitoring report on the right to freedom of religion or belief. The Norwegian Helsinki Committee Freedom of Belief Initiative project systematically monitors the developments on religious freedom in Turkey. I have some copies in the back of this report. It's available both in Turkish and English, and on our website as well. We have found that in addition to not protecting the right to freedom of religion or belief fully, that means with all of its components, Turkey struggles to comply with the principle of neutrality and obligation to ensure pluralism. And these shortcomings have implications on two different spheres. One, the freedom of religion or belief, and the second one, the role of the state as a facilitator of religious practices and provider of religious public services. Flaws in the observance of the principle of neutrality directly impact the protection of religious freedom. As mentioned earlier, states are required to be neutral in all their transactions and practices regarding religion or belief. Decisions by the state based on the views of certain religious authority as to which beliefs or manifestations of them are legitimate are also incompatible with the principle of neutrality. Despite this, public authorities in Turkey, including the judiciary, have decided that the Alevi gem houses are not considered as places of worship. The Baha'i faith or Jehovah's Witnesses do not constitute religions, and conscientious objection to military service is not accepted as a manifestation of religion or belief. The fact that the point of view of the Directorate of Religious Affairs has been taken into account in all these decisions casts serious doubt on Turkey's compliance with the obligation to observe the principle of neutrality. Neutrality and pluralism are highly relevant for the effective protection of the right to establish places of worship as well. Until 2003, the term place of worship did not exist in our public works law. The term mosque was used. This meant that until then, it was not possible to establish a new place of worship other than a mosque or a masjid. Along with the EU harmonization laws, the public works law was changed, and it has become possible, in theory, to establish places of worship other than mosques. Because although the right to worship is constitutionally protected in Turkey, when we look at the outcomes, what happens in practice, when we look at the outcomes and really what happens in practice, we see that the Alevi community, Protestant churches, or Jehovah's Witnesses are not able to acquire place of worship status for their worship places. They worship in their respective buildings, and most of the time they are tolerated. That means they are not interfered with in their worship. However, these places are not legally recognized as places of worship. This means that they are unable to take advantage of the tax benefits and public funding offered to legally recognized places of worship. The reason for the denial of place of worship status for the gem houses lies in the notion that only mosques and masjid are viewed as legitimate places of worship for Muslims. There are three justifications given for this denial. The first is based on the opinion of the Presidency of Religious Affairs that Muslims worship in mosques. And the second one on the law that governs the powers of the Presidency of Religious Affairs only refers to mosques, and that a law that was adopted in 1924 on the closure of Dervish lodges would be applicable to gem houses. These reasons, however, are not convincing. The law cited in such decisions on the Presidency of Religious Affairs governs its duties and powers, and that cannot be interpreted to mean that there are no other places of worship other than mosques. Meanwhile, contrary to what is argued, Law 677 on the closure of Dervish lodges does not constitute a barrier to the recognition of gem houses as places of worship, because if gem houses were within the scope of that law, they should not be allowed to exist as they are. In the case of the Protestants and Jehovah's Witnesses, these communities report that the regulations on places of worship are formulated with the characteristics of mosques in mind and are very difficult to fulfill for them. They complain that when they apply to the local authorities for the recognition of their buildings as places of worship, they are rejected because their buildings don't comply with these regulations. Then, when they ask the municipalities to show them a plot where they can build places of worship, they are told there are no places designated that can be allocated to these groups. As a result, the right to establish place of worship means a trapped right for these communities. The state's failure to fully remain neutral in relation to the right to establish places of worship results in the recognition of a limited and selective pluralism. The officially recognized religious diversity in this context does not correspond to the religious diversity that exists in fact. Determining which actions should be regarded as manifestations of religion or belief in worship or practice, or which beliefs should be recognized as beliefs or religions, are not within the competency of the state. With respect to such issues, the reference point should be the views of the believers. And this brings us to the issue of conscientious objection to military service. Although conscientious objection is a human right protected within freedom of religion or belief, Turkey does not recognize it as a human right. And the Turkish Constitutional Reconciliation Commission has not reached an agreement regarding the recognition of this right. And two military courts, however, have recognized this right in 2012 with reference to Article 9 of the ECHR. However, they discriminated based on the beliefs of the applicants. The request of a Jehovah's Witness was accepted and he was acquitted, but that of a Muslim was rejected on grounds that conscientious objection has no place in Islam. Hence, the court made a theological assessment of whether there is conscientious objection to military service in Islam or not. Again, here we see the involvement of public authorities in their decision-making with theological assessments. As far as pluralism is concerned, states' responsibility presents itself at least in two spheres, as I said. First, ensuring that diverse religious or belief communities can exist together peacefully. And second, that belief communities can maintain their autonomous existence. It directly concerns not only the organization of the community as such, but also the effective enjoyment of the right to freedom of religion or belief by all its active members. Respect for pluralism requires that states make it possible for belief communities to maintain and develop their identities, characteristics, and practices. This means that in order to ensure plurality in society, states have to refrain from interfering in the internal affairs of belief communities. The lack of legal personality of belief communities in Turkey makes the autonomous existence of belief communities highly vulnerable. No belief community in Turkey has legal personality as such. Legal personality is an enabling right which empowers belief communities to collectively exercise their rights. Without legal personality, they cannot even sign a contract as a belief community, to rent facilities for worship purposes, or to own property. And the foundation and association formulas in Turkey have significant shortcomings in this respect. The use of religious titles forms part of the internal affairs of belief groups and should not be it should not be an issue that is regulated by the state. In Turkey, certain religious titles, mostly used by the Bektashi tradition, are banned under an old law adopted in 1924. Although this law bans numerous titles, few people have been penalized based on it. And even though there is no domestic legislation that regulates the use of other religious titles, administrative warnings have been given in cases involving the use of certain titles. There is no legal provision that prohibits the Greek Orthodox Patriarch from using the title Ecumenical or requiring the Armenian Apostolic Patriarch to use the title Patriarch of Turkish Armenians. Public authorities have also warned the Chief Rabbi to change his title to Chief Rabbi of Turkish Jews instead of Turkish Chief Rabbi. Similar interference occurs in relation to the election and appointment of the religious heads of the so-called Lausanne minorities. In Turkey, different rules apply to the appointment of religious officials based on their religious affiliation. The Directorate of Religious Affairs appoints imams who work in mosques. There have also been interventions in the appointment of non-Muslim high-level religious officials of the Armenian Apostolic Church, the Greek Orthodox Church, and the Jewish community. These interventions are not based on law, but what may be called an established practice by the state. State officials have indicated that priests who work in the General Synod of the Greek Orthodox Church must be Turkish citizens. Officials also stated that members of the Greek Orthodox Church could apply for Turkish citizenship. Yet there is actually no legal basis for a requirement that the members of the General Council must be Turkish citizens. And the second sphere where the principle of pluralism is applicable to concerns the public religious services and facilitation of religious practices by the state. Turkey's unique state-religion relationship has always included the idea that state would assume the role of religious service provider, particularly in areas where the state holds monopoly. Perhaps this role is most visible in the Presidency of Religious Affairs and the provision of religious education in the school system. This may be also called the facilitating role of the state with respect to religion. With some recent legal changes, the state provided various types of religious services or facilitated them to a certain extent. These changes include payment of the electricity bills of places of worship that are recognized by the state as such, provision of religious education in prisons, and consideration of attendance at such education in the evaluation of good conduct of prisoners, and the problematic introduction of only optional Islamic religion courses in secondary and high schools. Discussions and governmental initiatives regarding the new constitution also indicate that the special constitutional status of the Directorate of Religious Affairs will remain in place. For example, the funding of the Diyanet's budget from the general state budget means that all taxpayers, whether they support the Diyanet's religious dogma, mission, and activities or not, do support the institution financially. And as we have seen in the case of I mentioned against Sweden, that this is not permissible. Similarly, funding of the Diyanet results in an unequal distribution of funds to belief communities. This also seems incompatible with neutrality as well as non-discrimination. A TESEV study found that 78% of those interviewed said that if the Presidency of Religious Affairs did not remain as a constitutional institution, it should be an institution separate and independent of the state. Only 21 said that it should be abolished and that each belief community should provide services for their members within their own means. I will just suffice to say that the existence of an institution like the Presidency of Religious Affairs, as such, is not incompatible with human rights standards. However, in the Turkish arrangement, certain elements of the Diyanet need to be rearranged in light of the normative demands of human rights law. For Turkey to comply with its human rights obligations, the government needs to carry out fundamental changes in relation to the Diyanet. However, as the state continues to claim responsibility for religious services as a service provider and facilitator, due to the existing problems in the implementation of the principle of neutrality, this is likely to lead to the deepening of discrimination. State monopoly over religious education continues to be an obstacle before the flourishing of the autonomous existence of belief communities in Turkey. Only the state can open religious educational institutions. As is well known, it is not possible to establish educational institutions that teach religion privately. And the state teaches only Islam. This does not reflect the religious diversity within Islam, as well as the diversity outside of Islam. And as a result, religious communities cannot train their own religious teachers, religious leaders, as well as their own communities. The recent democratization package had raised expectations for the resolution of this problem, which would then also lead to the opening of the Halki Theological Seminary, but this has not happened. To conclude, Turkey is not a theocratic or confessional state. It's a secular state with significant human rights commitments in the sphere of religious freedom. But Turkey is struggling with protecting the right to freedom of religion or belief fully for all, and the obligation to comply with the principle of neutrality and to ensure pluralism. Many aspects of religious freedom inevitably require state regulation and decisions of public authorities on a daily basis. And where there is a lack of solid commitment to state neutrality and pluralism, which is inseparable from democracy, the protection of freedom of religion or belief will suffer. And as a result, human beings suffer. While the changes that are necessary to create a legal framework that will bring about the effective protection of religious freedom for all, including believers and non-believers, members of majority and minorities, the changes that are required for this seem obvious. The real issue seems to be to bring about a fundamental change of mentality that will embrace these necessary changes. Turkey's political parties and vibrant civil society, which includes our belief groups, will continue to have the change to bring out this change in the context of the new constitution. Otherwise, discrimination is bound to become more pervasive and deeply entrenched in various aspects of life. I thank you.